Today, David Sheril, Chris Porcelli joining Ivory GC. Thank you both for being here.
My pleasure.
Thanks for having me.
So I think we'll start with just some quick introductions. You know, who are you? Who are you working for? What do you do? What's kind of your professional background? And then we'll go from there. Chris, you wanna start us off?
Sure, sounds good. I'm Chris Porcelli. I am the General Counsel, Corporate Secretary, and Head of People at Aterian Inc. We are a publicly traded e-commerce company. We have 6 brands that mostly sell on Amazon. Our most well-known brand is Squatty Potty, the #1 way to go #2. We have some other brands in home and kitchen appliances, essential oils, steaming, and photo paper. And yeah, very excited to talk to you, Brian, and you, David.
Great.
All right.
Thank you.
Hi. We are a major consumer of many of those products, so I'll leave you guessing which exactly. But a lot of them. You're doing good work. So I'm David Sheril. I'm currently the GC of Castle Lanterra, which is a real estate focused acquisition, management, disposition, and lending company and platform. We do primarily multifamily properties of any size and any location that makes sense, generally in the $50 million to $200 million size per property. So like I said, multifamily, office, mixed use, and we have some warehousing and some development that's on its way up.
And both of you are in the New York City area, right? And so just kind of quick backgrounds about where you're from, where you're living now, where your companies are located, things like that. Chris, why don't you start us off?
I currently live in Nassau County, Long Island. I went to school. I went to St. John's for undergrad. I went to NYU for law school. After NYU, I started at Cadwalader in Manhattan, and then I went to Sidley Austin, and then I came to Aterian.
And so for me, I'm originally from the south of England, not the south of America, as you may be able to tell by the accent. Now a resident of Clifton, New Jersey, which I like, which is North Jersey, very, very close to the city. It's the crow flies, it's probably 4 miles to get there. Yeah. That's easy. Yeah. Castle Lanterra is now based in Suffern, New York, just because there's more space and it's closer to the principal. And I came here. I went to law school. I actually went to law school at St. John's. I went to evening school because I was working full time. From there, I went to Simpson Thacher, where I was a litigation associate. From there, I went to Hahn and Hessen, which is now called Thompson Coburn. And then from there, I ended up at, I went straight to Castle Lanterra.
Nice. Okay. So, I think let's start by talking about the legal departments that you're in now, which are small. And then we'll talk about how they've kind of changed and evolved over time. David, why don't you start telling us about your team, where you are now?
Sure. So I'm currently a team of 1. I'm just the jack of all trades, which I often joke that I'm fortunate that not so many people read the classics here. They don't realize that the end of that sentence is master of none, which I always remind people. But in this case, hopefully people don't think that. No, I was the first in-house lawyer brought into the company. I was brought in when the portfolio was large enough and the legal spend was large enough that it was worthwhile to have someone in-house. I have had people join my team on and off. We were going to expand, and then we were thinking of expanding sort of mid 2022, and then of course with financial markets and interest rates, which impacted everything, but significantly impacted the real estate market and certainly the real estate transactional market, we decided that wasn't the time to upsize, and so we stayed. At the moment, it's just me.
Chris, how about you?
Yeah, much respect for you being solo over there. I currently have one other lawyer on my team, and I feel like I'm drowning at times. You must be doing great work prioritizing. So for me, I was hired here to be the number 2 in the legal department. It was about 4 years ago. I've since ascended to be the number 1 of the legal department. I had a team underneath me. Currently, it's just one other lawyer. I had at one point hired. I came in to build the department, and I hired someone to, who I had focusing on my SEC filings. I had someone focusing on my IP. I had someone who was my M&A and commercial agreements person, and it was great. Giving the work out to everybody. And as our industry has changed, as our company has changed, our team has shrunk back down to the 1. So now it's been a learning experience, as I had really trained the one person to be like, the one person who was left was my IP person. And now I'm also splitting up, my SEC filings with him as well, and my commercial agreements as well. So it's been a great task in delegating, and then taking back, and then redelegating.
Yeah. So what have some of the strategies been that you've used as the department's grown and then reduced in size? What are the challenges you found, and how have you addressed those?
Yeah, the challenge is that I was really focusing the one person on our IP, and I was like, okay, this is what I want you to learn. Our training budget for you is devoted to you learning this, and all of that. And then I was training the other person in other stuff. And the challenge I found was that I know SEC filings from my past firm life, so I was training the one person, and then they're no longer with us, and I took it on myself. And I feel like that's a lot of lawyers' problems, is they take on too much themselves and don't delegate back. So that was one of my biggest problems was I can't be spending all of my time on our Form 4 filings when we have a major board meeting coming up or some other major thing that I need to be focusing on. So just delegating back these tasks that I had taken from the departed employees. And I think the thing that helped the most is just being organized.
Yeah.
My teammates. Yeah.
Go ahead. Sorry.
That's it. When the commercial agreement and M&A person, when she left our team, having a huge offboarding with her has been, so beneficial, because she left a huge document of everything that she was working on, form agreements, so it makes it so easy for me to now train the one person remaining on my team and deal with the bandwidth issues.
That's what I was, the first thing that came to mind as you're talking is, not only do you lose the capacity with the attorney that moves on, but you lose whatever institutional knowledge they contained. And so if you can put processes in place to retain that institutional knowledge, great. David, have you run into that similarly, and kind of how have you handled it?
I have run into that. Interestingly, not so much in my department, but as starting, I guess, in 2020, COVID and onwards, as the job market was so tight, and so starting salaries, or even moving salaries and compensation, companies were competing with each other. There was quite significant turnover in the industry, just because, I had someone come into my office and say, I don't know how to tell this to the head of asset management that they reported to, but they were like, this company's offering me 6 figures more than I'm currently making. So, it's tough to match that. So there was enough turnover that was absolutely a problem that, for me, is my concern. I always say that what I try to address, certainly what I think a legal department and a general counsel in general, sitting above sort of in the executive level, needs to address across the whole company, because a lot of people aren't so good at that and they're not so focused on that, is minimizing the unknown unknowns. And if somebody leaves, the warm body can be replaced. If that institutional knowledge, like Chris said, if that institutional knowledge is not, you can never capture it all. But if you can maximize that capture before it leaves, that is huge.
Yeah.
And it avoids costly mistakes. It avoids legal issues. Right?
Yeah.
You don't want someone who was dealing with a vendor and they were negotiating for, replastering an entire building, and it's a $700,000 contract, or someone's re-roofing a building for 900 grand, and now that contact leaves. Where are we? Have they been paid? Haven't they been paid? And vendors get very antsy. The first thing they'll send you a demand letter, and if they could, they would then take a time machine back in time to file a lien faster than they even serve the demand letter, because they have to serve the demand letter first. And then if that happens, guess who that comes to? It's me. And now I have to scramble and educate myself on it very, very quickly.
But we have to work through checklists, right? I mean,
yep.
Or we have, even if they're mental checklists of, did we do this, that, and this? And when someone leaves and they didn't leave behind a paper checklist or a digital checklist, it's like, where are we on these things? Did that box get checked? That's the thing. Chris, you mentioned you started building the institutional knowledge, over time. What was your approach to that?
Yeah, it's just building. First off, it's the relationship with my teammates. So even if we are, unfortunately laying them off, having a mature enough relationship with them where they understand where it's coming from, and giving them enough of a ladder. That's not the right word, but enough headroom before their drop dead date, right? So also they can find another job, right? And that they respect you back, where it's like, okay, hey, like, I'm going to make this as easy as possible for you, because I know that you're going from, 4 lawyers to 3 or 3 lawyers to 2, and your time is going to be even more compromised. So it's, from the start here, I've been building out like an incredibly drive of all of our agreements, all of everything that we're working on. So just having, her transition doc that has links to stuff on the drive. So great.
Yeah. One thing that I guess we as lawyers who worked at law firms take for granted, but I didn't realize pretty much no other industry has, is a document management system. That was first day training as a first year associate, right? Whether you suffered through, all of those older companies that we all had to suffer through, but there was version control, we had everything. And I came to the company, and like many companies, if there hasn't been a lawyer there, that doesn't exist. And I found that for me was very eye-opening.
100%.
So I actually with asset managers and acquisitions people and accounting and HR and everyone, I put together, it took a year, but I built from scratch a DMS. We use NetDocs now, that's what it's based out of, but there's no written anything or email communication that can't be filed somewhere and you can't search for, and it's all integrated into your Outlook. These aren't mind-blowing inventions for attorneys.
Right.
People, first of all, getting people on board with even understanding what it is, because try explaining a document management system in the abstract. It seems like, of course I can do that. It's more difficult than you think explaining that to accounting people, not necessarily accounting, but people who just, and they have a way of doing things, and the company's been running for 10, 15, 20 years that way. So, but it's really made things much easier. And like Chris said, you can even have someone create a transitional checklist or a transitional doc and include links to those documents on the DMS. So it really makes it so much easier.
Yeah, because I think we've all been. I think Chris, you said you went to Aterian as the number 2. David, you had joined companies as kind of the first in-house hire, and because legal touches so many different aspects of the business, it's like you need to know where some things are, at least at a high level, from finance or from product or from sales, certainly. Walking into a situation where that may not have been thought through even consistently across functions, I think that's a role that legal can play, that to really add value to the business, is kind of a consolidator of information, where we are involved in a variety of the aspects of the business where we can kind of add value, bringing some things together and kind of getting some consistent operation across the board. Chris, what's your experience been along those lines at Aterian?
Yeah, I think the one thing that I've tried to consistently express to my business partners is to bring me in earlier on everything.
Yeah.
And I think that helps me manage risk and helps me drive us towards positive solutions. I think a lot of business folks tend to see legal as a roadblock. And I don't, that's the last thing I want to do. I'm a partner to the business. So I want to help you get a more creative solution or just get this done. You get an agreement for someone, let me see it right away. And I could tell you, am I going to have comments on this? Can we get hurt by this agreement? If not, let's just go for it, right?
Right.
I'm not going to slow you down. I'm going to speed you up and make this better. So I think that's really it.
Yeah, and even having just having the opportunity at the outset to just weigh in on are there any showstoppers here, or is this like a complete green light, right? Nothing to think about. Just having that initial gut check, or is it somewhere in between, which it often is. In which case, okay, is this going to take 30 minutes to look at, or do we really need to take a close look at this and let's dissect how this portion of the agreement or this aspect of the transaction might impact other areas of the business that your business, the primary business lead, may not have visibility into, but because you've worked across the business, you may be able to connect the dots. David, it sounds like looks like you've had some similar experiences.
Yeah, Chris is singing my song and/or preaching to the choir. He's absolutely right. So I'm fortunate that also, I think we all have to deal with this perception that legal can be a roadblock. Fortunately, given, I think, the transactional nature of commercial real estate in every aspect of it, I think that stigma still exists, but to a lesser extent. What I tell people is, they say to me, we'll bring you in when something is legal. And I said, every single relationship that you have with a counterparty that is not a blood relative is legal in nature. Yeah. So I don't want to be brought into anything. What I don't want to be is I don't want to be CC'd on 655 emails a day just because you thought to yourself, hey, why not? But like Chris said, you got to strike that balance. I tell people, bring me in at the first thing that you think to yourself, is this worth running by David? Just send it to me. What's the worst thing that I'm going to say? I'm going to say, all good, you don't need me right now. But having that check, what the way that I have explained this to young asset managers more than acquisitions, because in acquisition, the first documents are legal, right? So I'm in there whether they like it or not, and fortunately they like it, but it's different on asset management. It's different. And so I tell people, I was like, I want you to minimize the number of emails marked urgent that you send me. And the way to do that, exactly like Chris said, just bring me in early. Just let me know from the get-go. Let me know from the outset if you think there's something here. That's right. Shoot me an agreement. And again, to something that Chris touched on as well, we have to, as general counsel, or as any in-house counsel, you got to strike a balance between what is worth pushing back on and what is not. So I will say I read and have drafted, all the boilerplate clauses, because as a litigator, I won some wild cases on boilerplate clauses that the other side didn't read. So I'm very careful with those. But if I have one tweak here, and let's say I'm not thrilled that the choice of law clause is Virginia instead of, but the property's in Florida, I'll put it in an email and say, hey, I'm not thrilled about this. It's fine. The rest of the agreement is fine. And frankly, Virginia courts ain't that bad. So, and it's close enough, we'll figure it out. So, but striking that balance, because there are times that I think not even necessarily a younger in-house counsel, any in-house counsel, you think to yourself, oh, I really want to avoid that stigma. But sometimes you sort of you just have to get used to that muscle of pushing yourself and developing that judgment of I know these guys aren't going to be terribly happy. I know the counterparty's really not going to be happy. But the bottom line is I'm here to protect the company and their assets. So you got to do it. So there's a balance.
Balance is 100%. And in relationships too, of striking, that does kind of get to the balance of, people can trust that when they bring you in, you're not going to blow up the deal for something that doesn't require. I mean, maybe you need to if it's justified, but not if it's not justified. And rarely do we. I mean, as we see in practice, rarely does legal blow up the deal, because those are the things that get you left off of emails or fired, right? Because it's just that the business needs to operate, and we can't be that roadblock. Chris, what are some of your kind of thoughts along those lines?
Yeah, 100%. legal, like commenting on an agreement, for example, there's times where I tell my counterparty, or like my business team, like, hey, like, you can leave me off this email and you could blame me, like, oh, I'm sorry, legal's being so annoying, but I know you want this in there. So like having a good relationship with them so they can blame me, and I don't care if like, oh yeah, Chris is being a jerk today, right? Like that's good because I have a good relationship with my team. They feel comfortable saying that in an email. Or if they don't want to push back, they just include me in the thread and be like, oh, copying Chris because he has some comments. And then, you know, I prefer to just pick up the phone and call their legal team on the other side. And I feel like that helps where like I'm not making my business team look bad by coming in with my unreasonable comments, which they're never unreasonable, of course.
Yeah. So curious how many emails, and you know, we don't have to put a number to it, but how are you managing along these lines, right? Of include me, right? Bring me in early, include me even if I don't have to weigh in, because it is nice for us to have visibility, even if we're not weighing in at every step along the way. I guess, you know, how are you managing emails? And I from a variety, I guess take that wherever you want to go with it. Either asking to be left on or left off. You know, where you file things. It's difficult. At least it is for me these days. Everyone I know has a system, right? What does your system look like? What's works for you? David, why don't you start?
Sure. So that is an excellent point. I mean, you could very readily be inundated and spend your every waking minute on emails, especially when things are busy or if there's a big emergency. You can certainly do it. The two ways that I have tried to manage that is, number one, I've always tell everybody knows, when in doubt, include me. Because like I said before, worst case, I'll say, I'm good. You know, just CC me when it goes back to the other side.
You file it away, you put it in a matter folder that you can reference somewhere down the line. But
exactly.
Yeah, it's nice to just have it. Yeah.
That's right. Exactly right. The other way that I have eliminated a lot of the initial back and forth, because there's a tough balance for people to strike, and sometimes it's not their fault. It's like, on the one hand, don't bring me in so early that you don't really need me and it's just clogging my inbox. But on the other hand, don't bring me in so late that I could have dealt with something and we could have smoothed this out and we could have avoided an issue. So that's a tough balance to ask people to strike, regardless of your function. Doesn't matter if you're legal, you're the head of a department, or you just manage one person. You know, it makes no difference what level you are. So the other way that I've mitigated that, and Chris mentioned form docs earlier, when things got slow for a brief period during COVID, I really hyper-focused on cranking out form docs for virtually anything and everything that we do as a company. Everything from NDAs, because again, if we're on a roadshow, if we have 3 deals and we're roadshowing them to investors, I could legitimately spend 24 hours a day, 7 days a week reviewing NDAs.
Yeah,
I would like to spend 0 minutes of my life.
And I want to come back to the form documents, because I'm interested in you know, how they were created, who fills them out. Let's sure. So I do want to come back to that. Chris, on the like email management piece, what are some, you know, what are you doing?
Yeah, so one of my biggest pet peeves is when someone says, "Oh, I was trying to spare your inbox." Mm-hmm. My inbox is ruined. I get like just copy me anyway. So I tell people to copy me on everything, right? When I was at the law firm, you know, it was different versus being here, right? I used to make sure I read every single email every day. Here, if an email comes through, I scan it, see if it's directed to me. If not, I'm okay leaving that till the end of the week. So you know, I do a Monday morning. I catch up on all my emails, make my little to-do list on my little notepad. And then at some point in the middle of the week, you know, like Wednesday afternoon, Thursday, maybe Friday morning, I catch back up and make sure I haven't missed anything important. I'm okay with my inbox getting ruined. It makes it easier for me.
I totally along those lines. I mean, it just I would rather at least have it, even if I'm going to scan it, and that gives you something, right? I mean, it's not going to give you what you need to go like and answer a question, but at least if something comes up down the road and it's like, oh yeah, I remember that, I remember scanning that. So, and I can go back and find it. And so at least you can have a better conversation than if you didn't get it at all and then can't find it. Yeah, I mean, it's an interesting, you have to have, I think, in this day and age, there's so many emails go back and forth, particularly in our jobs. I mean, you have to have some system. I mean, you can't survive if you're just, trying to stay afloat. David, on the form agreement piece, so what strategy did you take to create the forms? And then how do you distribute them among your team so they get filled out? And then I guess we can also talk about generally, and Chris would hear from you too on this topic, just how do you how many agreements get done on your paper, and which do you insist get done on your form, right? And where which ones aren't, and where are you more lenient on that? So I know there's a lot there. Why don't you just take it one by one?
Sure, but I see that you've got the nuance here, because that last point is a very important one, and I think a lot of people may not be cognizant of it. So the form document started. I found myself starting over time. Generally, in a transaction, if you're a seller, you're going to use your purchase and sale agreement. You might, if someone wants to do on-site due diligence or other due diligence before, we'll use your access agreement. You do enough transactions, or I do this, I have a cribbing document. And sometimes if I have a few minutes, or if I'm on a meeting that is running long, I would just organize it into parts. And then you do enough transactions with a large enough variety of counterparties. A, you get the experience to realize what is important. B, you get the experience to realize what's reasonable, because it is critical. If you want a form document to actually fly, you have to be reasonable in it. Because
David, when you say you use a cribbing document, are you referring to like if you're working on the counterparty's paper, you're looking at a document with your sample, your template language, your preferred language, and when you're marking up the counterparty's agreement, you'll pull from that cribbing document? Is that what you're referring to?
That's precisely right. I have a checklist of things that I need to see in the agreement, whether we are a buyer or a seller, whether we are a vendor offering something, whether we are the ones hiring a vendor, whether we are managing something, or whether we are going to manage someone for someone else. There's things that I look for.
When you're using the cribbing document, because it would certainly be easy to copy and paste the whole section and replace it, right? And I mean, and that's going to drive the counterparty crazy. And,
right.
and we use a tool at Ivory called Ivo, where similarly we can put standard language in there, and it uses AI to kind of try to be as precise or surgical, right, as you can be.
Right.
Do you, when you're actually using that cribbing document and modifying the counterparty's agreement, are you just kind of using the cribbing document as a reference and trying to be as surgical as you can, or what strategies do you use there?
So great question. For me, the smaller redlining I see, or the less is the right word for that, I think. The redlining I see, the more that consciously and subconsciously I'm going to want to be forgiving in a document. So I just presume that everyone kind of has that mindset. There are certainly law firms that I have dealt with that shall remain nameless, who are like, no, it's our form. And if you, heaven forbid, try to modify anything that, the clouds parted on the top of Mount Olympus and Zeus handed down this intercreditor agreement 2,000 years ago, and heaven forbid you try and change something, you'll incur the wrath of the gods. But for the most part, people want to see two things. People want to see you be reasonable. Everybody knows, look, you're trying to, whether it's in litigation, zealously advocate, but also in transactions, you're trying to zealously advocate for your side, right? You're trying to have a good deal for your side. But if you can be reasonable and exactly like you said, Brian, be surgical. There are so few paragraphs or clauses that I would copy paste. Very, very few.
Yeah.
Because
so you're just going through, you're just using the cribbing document as a reference, and then just conceptually, okay, I could see even, taking that cribbing document and highlighting, right, in different colors, like the essential part of this section, that's green. medium priority language, like that's yellow, whatever it is. But yeah, it's interesting. Chris, for form documents at Aterian, what are you using? How have you developed it? What's your approach?
I mean, it's a bit different for us, right? We're not, we did a bunch of brand acquisitions a few years ago. But like the main agreements I'm entering into, I don't really have the type of leverage it seems you might have. I'm entering into an agreement with Walmart, right?
Yeah.
It's tough there. It's
so interesting. I feel like that's a whole other conversation in of itself of like, how are you handling that? I mean, we have clients that they just, particularly when Walmart's a customer, right? And you get customers always right, and it's Walmart. So how much are you really going to get accomplished here? Why don't we talk about that? How does that come up? Whether it's form agreement or just kind of handling your commercial agreements. What do you have?
I mean, it's always their agreement generally, right? Like I do have my form NDAs, my form independent contract agreements, but that's unimportant for this conversation. With someone like that, right? I'm not going to get almost any comments in, right? I try. So like the big things that I focus on there are, well, first off, I make sure we can comply with the agreement, right? Like, we're consumer products, right? Like, do we have the right insurance? Yada, 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 which, of course, if we don't, then got to talk to business partners. We sure we want to do this deal? Then I got to change our insurance. But like with that, I'm really focused on, the how do we get hurt here? And that's it. That's where I try to push back on, because I have the smallest amount of leverage, and it's making sure that if this deal does go bad for us, can we get out?
Yeah.
What is the termination provision?
Generally, what types of agreements are you entering into with the large counterparty customers? Like what agreement is it? What are the terms, and how big of a what's the total contract value roughly on average?
Yeah, I mean, so it's I say Walmart, but I'm talking about like all these different agreements, like like with like UPS, like FedEx, right? Like the agreements with Amazon, right? So
supply chain type, like distribution type agreements. Is that
yeah? So like getting our products into places or getting our products to places, right? We never have any leverage here. So it's really I try to change, like I'll change an agreement from like a 3-year term to a 1-year term, and like the termination provision, because they always automatically renew. So I try to get it from like a 90-day to like a 30-day, and generally I do get wins there, and that's the best way to do it, because my business partners they want to, like we're trying to grow our business. We have to move forward with these deals. So
right, yeah. Yep. And David, it sounds like in your business at Castle Lanterra, it's less. It's your real estate and more transaction based documents. You're much more relying on forms. So a little bit different in that regard, but similar types of practices.
Yeah, yes and no. I mean, what I find is as a landlord, especially in the office buildings or in warehousing, like Amazon was looking at our warehouses. We've got agreements, and then we have agreements for cable and internet contracts with, let me tell you, negotiating with Verizon or AT&T is enough to drive any sane person completely insane. And it's like, wait, guys, you want to use our buildings? Surely I should get some kind of deference here. No, but, no, zero. But certainly negotiating a commercial lease of any kind, right? If you want, Papa John's is not super aggressive and pushy, but you want a Papa John's downstairs in your mixed-use building, because it's a tremendous tenant to have downstairs. They know that. They're smart. They're well aware of their leverage. Yeah. So there is only so much you can do, right? Same with Amazon. Same with, we've had chip manufacturers in one of our office buildings. And, their chips are generally used for AI and that kind of stuff. And so as time has gone on for the last, I would say, 7 years, their leverage has increased, and their demands have become more and more absurd. So where do you juggle that? But what Chris said is exactly right. At the end of the day, this is going to be an anchor tenant. You need this tenant. They know you need them. They know you need them. Where can you push back? So I do the same thing. I absolutely hate auto renewals. I try to push back. I try to get in any contract I can, and you can't always get it in a lot of things, but with some vendors or whatever, you try and get that either immediately or after X number of months. Anyone can terminate without penalty upon, and then you fight. I'd love to get 30 days. They want 5 months. Can I get 60 days? Can I get 90 days? Right? There's a lot of that leverage there. And the other thing that Chris touched on, which is absolutely critical as in-house counsel, as a general counsel, is I have to make sure that the business team, and in my case, because it's a privately held company, the principal understands what we are agreeing to, what that means for us practically, how it is different than our regular terms. If these
and how do you track that moving forward, right? If you can,
absolutely.
That's a tough one, I think, these days. I mean, there are platforms out there like Luminance and others where you can add contracts to a contract management system. They can OCR it, maybe use AI to pick up the terms, summarize them for you. Those are expensive.
Yep.
Yes.
They're great, but I mean, and we're this is the series is really for small GCs, for small and growing legal departments. We're working with limited resources, right? So like, how do you? Yes, we'd love to know and make sure that all of the business folks know what terms in the contract we just agreed to that they need to comply with, but the business teams have turnover, right? And it's making sure we've got kind of across the organization compliance practices in place. One, difficult, probably impracticable, which is a word only used by transactional attorneys. but it's hard to implement. Chris, are you guys doing anything along those lines, or what are you thinking?
So this is gonna sound super small legal department-y, but I have a Google sheet that has agreement with X, terminated by XYZ, right? And then like deliverables, and it's sloppy. It probably doesn't make sense to anyone but me and the one person on my team. And then I also, embarrassingly, I make calendar events, right? Like, hey, do we want to terminate X agreement? We have 30 days. Now's the day to give notice. And like my calendar's littered with those.
I mean, it's just so interesting because when you have those tools as your best option, and I do think, I mean, they're not the best option. You can go out and pay a fortune, or you can go buy. There are tools out there available to pay to do that better, but they're expensive. It just shows where there's opportunity to improve if you can find the right tool, kind of at the right cost. David, compliance, ongoing, contract compliance. What are you guys doing there?
So fortunately, most of our contracts, I have standard agreements for everything, especially vendor contracts, management contracts, if we are managing a property on behalf of someone else, or if we have third-party management. And so those kind of things generally won't change, because where we have the leverage to use our contract, I actually have drafted, I took the time, again, after there was a bunch of turnover in the industry, I took the time and I drafted a policy, and it is a page and a half, and that is it, because a policy longer than a page and a half will not be read. And it's basically the procedure for how to engage in any transaction of any kind of relationship from the legal perspective. And point number one is, here are the legal documents. Again, we have a DMS in our document management system. There is a templates folder that everyone can access with a click of the mouse. They don't even have to open a web browser. They can do it straight from their desktop, right? And they can open that, and what's good is I can update the template. I can create a new version. It doesn't matter. What's going to show up for them is the latest version. So they're always going to be pulling consistently. So with that, a lot of the time, I will know. So let's say a counterparty does want to change a material term. Let's say we've tried to push back. No, they refuse to allow termination without cause upon 30 days. They're like, we'll give you 90 days, and that's the least we've ever given, since the invention of the chisel, right? That's what they're willing to do. So that is something. So two things. Number one, I will save that as part of the contract name in the DMS. That's one. Number two, I'll do exactly what Chris said. I don't mind getting a lot of alerts on my phone or my Outlook calendar, because that's how you don't miss things. So anyone on that contract, me, the asset manager, if there's a junior person in asset management, I'll have them on it, and someone in accounting. Maybe it'll be the controller, maybe it'll even be the CFO, depending on the contract. We will all have that, and I'll say, and I'll put the date, and then I'll do a week reminder. Right, so remind me 7 days before. That'll pop up on someone's calendar, and we have a week to decide. So what you don't want to do is have 3 hours to decide. We have a week to decide, right. And it works. And then the truth is that we have corporate level asset managers, and they have assigned assets. If it's their asset, they are tasked. We're all grown adults, and I tell them, remember, this contract is different. Put this somewhere that A, you'll remember. B, if you get hit by a bus, someone else will know about it. And then you've got me as the backup.
Yeah.
But there's absolutely right, Brian. There is, again, people see us as a cost center and as a roadblock, and we are always fighting that stigma. Me rolling up and saying there's an incredible AI tool that will do all of this for us, it's 40 grand a year.
Right.
That's 80% of my budget.
Yeah. Well, switching gears a little bit. So we talked, previously about outside counsel management, right? And this is, a little awkward for me as outside counsel, but I'd be interested. Every in-house, I've been in-house, and every in-house counsel has to deal with this in some capacity. I'm going to just leave it there. Chris, discuss.
Yeah. I think it's very important for me to have a very good relationship with my outside counsel, right?
Yeah.
That I'm going to them. I don't go to them every day. I don't go to them, that often. But when
what do you use your outside counsel primarily for? Just kind of give us a quick. Yeah.
So just sanity check on our SEC filings, right? Occasionally in 8K, I have them double check our Qs and our K, right? I feel like that's the right thing to do, especially with how busy I get around those times. Occasionally, if I have a question about, employment agreement or something like that, I might reach out to them. If we have litigation, which thankfully we don't right now. If we have litigation, obviously they handle that for me. Our IP stuff,
Are you working with one firm, or do you have a couple outside counsel?
No. I shop firms. I shop firms because budgets matter, right? So
right.
When I came here, we were using one big law firm for almost everything, and that was very expensive. So now I use a majority. I use a slew of smaller firms. And
where did you find those relationships with the kind of more regional? Because those could be. I mean, we all know it's easier to find someone who's at a larger firm. I mean, but it can be harder to find some of the smaller, medium-sized regional law firms. So I found some recommended through Tech GC. Okay.
Yeah, I found some just through my network. Right now I had questions about expansion to Europe, for example, and when I was at Sidley, there was a German lawyer who sat next to me, right? And he runs his own law firm. So I just got an engagement letter from this week to talk about expansion in Europe. So the network is huge there.
Yeah, it is. David, how about on kind of high level outside counsel management on your end?
Yeah, I would just say ditto to everything Chris says. To me, the relationship, the reason that I'm going to outside counsel is because I'm not comfortable doing it myself. Something that I'm 100% comfortable doing myself, I'm not looking to have that spend from legal budget. So, and the person I'm going to, I trust their judgment. I trust their experience. I trust their expertise. So it's critically important that we have a good relationship. And so for example, this is just my little personal thing. I don't believe in relationship work. I believe that if I asked you to do something, even if it's suddenly on a Friday at 2 p.m. and management needs an answer, by 4 p.m. and hey, can you just do this, that, the other? I always tell them, bill me for it. I am not looking to take advantage. As I told you before, I certainly, again, given what my budget is and in transactions, if a transaction is very complicated, a budget can, but like legal spend can balloon. But generally speaking, give me the counterparty, the size of the asset, where it's located. I can, and the firms that I think I'll probably use, I can probably ballpark that final invoice to within 5%.
Yeah.
So if it fits within the mean, I'm not going to nickel and dime. I will push back if there's some stuff, but yeah, it's the relationship, and finding them is really through relationships. Like Chris said, I mean, I have people also from my time at Simpson, from my time at Hahn and Hessen, either them directly I've used, for people that they have known, and then counsel that I have used for example, a construction litigation in Colorado. I love our attorney. He's doing a great job. If I have a construction litigation issue or a construction defect issue in New Jersey, I'm going to call him. Hey, who is you in New Jersey? And so even though we sit, because exactly like Chris said, we use 10 different law firms, maybe more. And a lot of it is about manpower. A lot of it is about cost savings. A lot of it is much more about expertise. Like we were paying a lot of money on a commercial development district in Florida. They have a ton of these things. They're just a money suck. They were just to float bonds. And they actually, once buildings are built, it's terrible for ownership. And we bought a built building. I was tasked with get us out of a commercial, a CDD, right, in Tampa.
Yeah.
But I called one real estate guy, who's highly experienced, who's a little out of the box, who does a lot of different things. He put me in touch with someone he said was the best. Unfortunately, that guy had recently died, but his partner put me in contact with another guy. And it was a gentleman, Southern gentleman, 3-person law firm. And this is all he did all day. And he was phenomenal.
Yeah. And I really liked, you got to know what you can do and know what you can't do, because it's just, you don't want to when you venture into territory that you don't know or don't know well enough. And that's a gray area, right? I mean, we got to have to make some judgment calls. I mean, we're, as generalists, we're going to be in areas that were not our specialist focus when we were at a larger law firm. But I mean, that's just the nature of the job. You've got options, right? You can't do it either because you don't feel comfortable, you've got the experience to do it, or because you've got too much work. And I wonder, what are you using, both of you using for like a gauge of, okay, when do I hire somebody, and who am I looking for? What's your approach to generally hiring? Chris, why don't you start?
Yeah. So that's a good question. Like, I've thought a lot about, do I hire someone to just do help me with my SEC filing work, right? Our public company reporting, and because I do all of that. And I think about how much do I really spend on my law firm to do that? Like, they do the sanity checks on the accusing case. I don't spend that much, right? This person's salary, someone who's confident, who I would be able to trust and not have to read every single word, would cost a lot more than I'm using the law firm for. So if I'm having them do something because I'm too busy, that's just why am I too busy, right? Like we did a reverse split this year right around the time of our 10K and a board meeting, and I was very, very busy, and we were doing our annual COLAs at the same time too, so I had to get letters out to every employee. So that was like the busiest time of the year for me, right? So our outside firm probably spent more time on the K than they usually do, because I didn't have time to spend on the K. But that won't be the case next year, right? We're not going to be doing a reverse split. We're not going to be, So you have to make sure you put things in context of why you did that spend. And that helps me think, would I hire someone for SEC reporting work? No, it doesn't make any sense. We don't have that much that work, and 8Ks are easy. Form 4s are easy. So yeah, it's the other stuff, right? Like, I had hired someone full-time for M&A, because when we were doing M&A deals like left and right, and then the acquisition in our industry died down and we weren't doing them, and then that person is really a commercial agreement person.
Yeah, and it makes it's a difficult, I think, and this probably, I mean, we're in the legal industry. We know the practice of law. I'm sure it's not unique to the practice of law, but I mean, our workflow ebbs and flows, right? And that's the nature of the job. And so, but it's hard. It's hard to manage. You know, you need a full-time person like today, or maybe this week, or this month, or the next 3 months, but you don't need them forever, right? I mean, you don't need them for the year, 2 years, 3 years. It presents a challenge. David, how have you handled that, Castle Lanterra?
Yeah, no, I think that's very accurate. I think that the primary issue is that we cannot see the future. And so it's really trying to take a long-term view and thinking, if things stay as they are now in terms of broader markets, right? So like if I'd have hired someone in February 2022, I didn't know that deal flow in the industry would drop by, let's say, 70%, 60 to 70%. 4 months later and stay like that for a while. But if we set that aside, that we can't predict the future, the way that I look at it is, number one, if this stays as consistent as it is, whether because I do exactly what Chris says as well, sometimes I'm farming stuff out because of expertise or a sanity check. I do a lot of sanity check stuff. I prefer that I'm confident enough to be able to say, hey, I may have missed something here. But also warm bodies, right? Like if we're closing 6 deals and I already have a portfolio of 28 huge assets to manage and then stuff going on, there's only so much that I can physically do before, and this is my biggest fear, things slip through the cracks. That is for me the number one thing. I will do anything within reason to try and ensure that things don't fall through the cracks.
And if you're going to hire somebody, the warm bodies, I mean, if you're going to hire somebody, it takes a while to train them. It's going to be an investment of time before it's a savings of time. And so that's a longer term, it's just a longer term play. And
that's exactly
we're talking about the dynamics of our job that make it hard at times to make those longer term commitments. And that's, again, not unique to lawyers in the legal industry, but
this is hiring
maybe particularly pronounced.
Yeah, it's hiring overall, but that is the answer. The answer is you need to look at it long term. It's really two things. Number one, it's looking long term. Let's say this stays this way. How likely is it to stay this way? And if it does, what does that mean for me? What does that mean for my time? What does that mean for what I can accomplish individually, or what we can accomplish internally currently, as the current structure is? And then also, as Chris said, it's the cost, right? Sometimes me filing out primarily to an outside counsel and me taking the back seat on that filing and having them do the first round of things and then me check their work.
Yeah.
How many times, there's, especially if you've got good relationships with firms and you're using reasonably priced firms, you're using sort of those more mid-size firms, think about that going forward. It's like, no, it really would take quite a bit of this before it would be a better value proposition to hire someone in-house with everything that comes with the salary, the bonus, the comp, 401k, etc. And again, especially in a small company, I'm dealing directly with ownership. So this isn't just like, we'll subsume it into the budget. Don't worry. They'll discuss some board meeting in some other country or some other state will discuss it. It's like, no, the office directly diagonally across from mine is going to open the door and come directly diagonally into my office and say, I'm glad you hired someone. Can you justify the need? And I'm going to have to justify the need in a relatively reasonable manner. So it's long-term thinking, which is not the easiest for anyone, but those I think are the tools to at least try and get it right.
Yeah. This has been a great discussion. As you both know, we end these episodes with words of advice you would have liked to hear, when you were starting your career and knowing where your career trajectory went for the rising attorneys that are headed to the place that you are now. Chris, what would you tell him?
Yeah, I would say that there's two important things, right? One is obviously networking, and I don't mean email a named partner at a law firm networking. I mean, be kind to the people you work with, right?
Yeah.
That's my version of networking, right? The associate underneath you, the associate above you, associate next to you, be kind to them because you might be DMing them on LinkedIn for help in a few years with the matter, right? And then two is say yes to anything that comes across your plate. Like you want to broaden your skill set. I think it's very useful to just know a little bit more about everything. If you say you're strictly an M&A attorney and some like a capital markets deal comes in at your firm and you're slow, take that deal, right?
Yeah.
It helps you learn just a little bit more, and it helps you. David, you were talking about knowing what you don't know. It helps you get to that a little bit more area of everything, so okay, I know this. I know I don't know it. I know I need help here. So then you can get broader. And then, finally, I guess I said two things. I'm going to say three things. Continue learning. Like continuous learning is huge. I get tons of emails, with like research, with like I call it research because it's a research folder, but it's learning. It's stuff that's teaching me more. I read those every day. I've done a couple of like those, Cornell courses that have taught me. I've learned employment law. I've learned IP there. I've learned, data policy there. Like, just continuous learning is so crucial, especially when you come in this role. Yeah.
Two things, that we've already talked about, or it's one thing we've already talked about, one that we haven't. It's a relationship. It is a relationship business. I mean, and it's not, aside from just like be a good person, be kind, right? I mean, it also is just a good way to progress through your career. You never know where it's going to help you. And then one thing that we haven't talked about yet in this episode, but the three of us talked about it in our a prior meeting, was that you've read 41 books this year. I think the number's 41. You're an avid reader, so you embrace that continuous learning and live it, which is pretty cool. And I need book recommendations real quick. This is not part of the outline or the agenda, but
that's tough. Most of my nonfiction books this year have really been about parenthood, because I just welcomed my daughter into the world.
Oh, congrats!
Nice, congratulations.
So I've got great recommendations there.
Go ahead. Give us one. Give us one.
Baby books.
There are other parents out there in the audience.
Yeah. I loved everything that Emily Ostler put out. She put there was Expecting Better, which is like what to expect when you're expecting. Talk about expecting better and like what you really should and shouldn't do during pregnancy. And then there was Crib Sheets by her, which talked about,
I did. I read that one too, actually.
Yeah, that was great. Just like, facts about babies and more stuff like that. And then, there was the Bottom Line for Baby. I can go on and on. I got like 10 books here.
Chris could be sitting behind a library of just baby books. An expert.
That's great. Well, that's great advice too. David, how about you?
Sure. In terms of advice, I would say don't be on a podcast with Chris, because he has phenomenal answers, and we'll take a lot of what you were thinking. But no, first of all, what Chris, the advice that Chris gave to any attorney, starting out or not starting out, I think is absolute gold. But in addition to that, I would say the two things that apply universally is written communication and spoken communication. Yeah. There are, and if that's 1A and 1B, 2 is constantly reevaluate your management style. I'm talking about in terms of openness. Do you accidentally forget to convey things? Do you, how are you accidentally siloing information, right? So in terms of being useful in that regard, and are you still open to listening? Are you giving enough credit to other people where it's due? Which again goes back to the internal relationship stuff, but the ability to communicate. I mean, I find a lot of attorneys just lack the ability to communicate, certainly in writing.
And there's always room to improve, right? I'm good at handling this type of person, but I really need like this type of person. It's just it doesn't work, and I've got to work on that. It's really really good advice.
Yep, it's that kind of management. And like I said, efficiencies in your management. Are you being efficient? Are you empowering those who you manage? And really, are you empowering yourself with everything to succeed?
Yeah.
Those would be my two, the only two that Chris didn't mention I think are worthwhile, as well as the communication and then reevaluate. Don't be confident enough to reevaluate yourself as a manager, because you're already doing it as a lawyer. That's why you're continuing to learn. That's why you're trying new things. Do that in your soft skills as well. There's no one in the world, with very, very rare exception, that can't improve their soft skills.
Great stuff. Love it. We'll put your contact information in the notes to the YouTube channel, in case there are people in the audience who want to reach out to you and say, hey, you mentioned this on the episode. What can we talk a little bit more about it? Whatever that might be. So feel free to do that, or add a question or comment in that section. Thank you both for joining us. This was great to have you on. Episode number 2, I think, is where this will slot into the lineup. So thank you for bearing with me and agreeing to do this almost as blind as I am on episode number 2. This was a lot of fun.
My pleasure.
Thank you, Brian. And yeah, if anyone does see this and wants to reach out to me, I'm happy to talk to you. Happy to.
Great.
Likewise.
Thanks, guys.
All right. Thanks so much.
Thanks.
Take care.